Good morning. This proceeding is being conducted by video and telephone. This is the matter of the United States versus Caswell Sr., case number 20-CR-626. Starting with the attorney for the government, can you please note your appearance for the record?
Good morning, Your Honor. AUSA David Felton for the government, and AUSA Shiva Logaraja is on the line as well.
Good morning, Mr. Felton, Mr. Logaraja.
A participant
Good morning, Your
has joined the conference.
Good morning.
Johnny. Has
James
left the conference.
I'm going to ask you to say that again because there was a...
Of course. So please the court, my name is James Koussouras, Koussouros. I appear this morning on behalf of Caswell Sr.
Has left the conference.
Good morning, Mr. Koussouras. All right, some preliminaries. Mr. Senior, can you hear me?
Yes, Your Honor, I can hear you.
Good. Mr.
A participant has joined the conference.
Mr. Koussouras has provided the court with a written consent form, in effect consenting to conduct this proceeding remotely. Mr. Koussouras, did Mr. Senior himself sign this form?
Yes, Your Honor. I visited Mr. Senior some time ago at the Westchester County Jail, at which time we reviewed it and he signed it.
Great. So, Mr. Senior, you're consenting to proceed remotely today after discussing it with your attorney?
Yes, Your Honor.
Very well. The consent form is accepted and we'll proceed remotely with a detention hearing. Now, it is my understanding that Mr. Senior was arrested back in December and consented to detention without prejudice at the initial appearance, and consequently this is the initial substantive bail hearing in this matter. Is that right, Mr. Felton?
Yes, Your Honor.
Okay. And I will, for the record, acknowledge that there has been a significant...
A participant has joined the conference.
A significant volume of written advocacy here. And I have before me and have reviewed Mr. Koussouras' motion, which was filed right back at the beginning of January. I have the government's response dated January 6th. I have Mr. Koussouras' reply letter dated January 26th. I have a reply filed by the government on January 7th.
Has joined the conference.
I also have reviewed a letter which appears on the docket at number 51 and is dated December 1st, which was submitted by the government in advance of the arrest in this matter. And finally, I've also reviewed the complaint in the United States against Chrysler, which is discussed in one of the government submissions. And finally, I have the underlying pretrial services report, which was prepared by pretrial back in early December. Counsel, I have spent a bit of time reviewing those submissions, and counsel can assume that I am at least generally familiar with their contents, and counsel should not feel obligated to repeat orally everything that's been set forth in writing. That being said, since the government continues to seek attention in this matter, Mr. Koussouras, what I'm going to do is ask the government to elaborate on the basis for their motion, and then I'll hear from defense counsel.
Thank you, sir.
Felton, you have the floor.
Thank you, Your Honor. And I won't fully recap the many submissions as the court just advised, and the government's position and remains that the defendant has not rebutted the presumption in favor of detention, and we agree with pretrial services recommendation that there is no condition or combination of conditions that will reasonably assure the defendant's appearance as required and the safety of the community. As the court knows, this is a presumption case because of the narcotics and firearms charges against the defendant in the indictment. Here, all of the statutory factors compel detention. There's the nature and circumstances of the serious and violent offenses charged, which includes charges of racketeering, narcotics conspiracy, and firearms possession. And this conduct, by any definition, and certainly by the statutory definition, is serious and dangerous. It's punishable by a mandatory minimum of 15 years imprisonment and a statutory maximum sentence of life. This isn't a simple drug rip or a simple slip into criminality. The defendant here is not just a mere participant or celebrity ambassador of some sort or an alumni representative of Gorilla Stone. Far from it. He sits near the very top of this violent organization under co-defendant Dwight Reed, also known as Dick Wolf. He's one of the top leaders and narcotic suppliers of a large-scale operation that was carried out by many more junior members of Gorilla Stone, including Nia Austin and Brandon Soto, and those working for them. And the defendant possessed firearms and has instigated multiple violent incidents in recent years. These violent episodes were sparked by the defendant over petty slights that ultimately resulted in more junior Gorilla Stone members in 2018 choking out a female victim in a diner, and quite recently, in October of 2020, a junior gang member shooting two people during the defendant's birthday celebration at a Miami strip club because a rival Crip told the defendant that he was flashing the wrong gang sign. The strip club shooting victims were immediately airlifted to a hospital for treatment, and the defendant has also promoted gang meetings and grown and amplified the gang's message and reach, or as he says in his own words, putting this apeshit worldwide. Releasing the defendant from custody risks considerable danger to the community, and any suggestion by the defense that the defendant is either not a member of Gorilla Stone or that he's merely merely a musician or an ambassador, it's simply not persuasive when the defense claims that. As we noted in our submission, the defendant's a full-fledged, unquestioned leader of the gang. This isn't about rap lyrics or promoting a musical career or marketing or promoting his music. It's about clear and reliable evidence of his gang leadership. As an initial matter, the grand jury, of course, returned the indictment charging the defendant in a racketeering conspiracy count. And in the defendant's own words, in a November 2019 radio interview with Nick Cannon, the defendant made clear that he is, quote-unquote, still ape, that is, a member of Gorilla Stone. And beyond the defendant's public admissions, what he says in private messages powerfully show his prominent role in the gang. In a September 2019 text message, for example, he bragged, "I'm under Dick Wolf, the godfather of all apes." Couldn't be clearer. He's under the founder and leader of Gorilla Stone, his co-defendant, Dwight Reed. Take another example. In an August 2020 text message, he actively promotes Gorilla Stone meetings, calling them mandatory. And he warns members if they don't show up, they will be wiped down. He requests that members pay dues to his co-defendant and friend, Walter Luster, also known as Shell. And in another example, in a December 2019 text message, he tells Dwight Reed's wife, the wife of the head honcho, "I ain't playing, sis. I'm putting this ape shit map worldwide." That is, he's serious. He's promoting and growing the reach of the violent gang. Second, there's the overwhelming weight of the evidence, which was strong the day he was indicted, some of which I just recapped and is further set forth in our written submissions, and is only getting stronger as seized devices from co-defendants, such as Chrysler, have been downloaded, inspected, and reviewed. Similarly unpersuasive is the defense suggestion along the lines that the defendant's Instagram is not his real life, that his public persona is an embellished work of fiction, that he only pretends to be violent on social media and in public, that this is all some sort of act and giant work of fiction. As we note in our submissions, the overwhelming, reliable evidence demonstrate that in private communications and on photos on his private iCloud, this defendant is a narcotic supplier and dealer, he possesses an array of weapons, and as Luster told Reed during a recorded prison visit, he even accidentally fired his gun during a poker game in New York City and always had a gun on him. That is, it's not just a bunch of hype. It's not a bunch of puffing and posturing and trying to seem cool on social media, which we know from the violent incidents. We also know it's not a bunch of puffing and posturing because when the defendant and his co-defendant don't think anyone is looking or listening, such as in their private meetings, photos, texts, and calls, there is rampant evidence of guns, drugs, and violence centrally involving this defendant. A third statutory factor is, of course, the history and characteristics of the defendant. It's worth noting he's a career offender with a very violent history.
A participant has joined the conference.
The charged conduct is all the more disturbing given the extensive criminal history and the fact that he engaged in this conduct while on pretrial release for yet another violent felony in New York State. Little need be said about the criminal history. He has 6 criminal convictions, including 3 separate first-degree robbery convictions for 3 gunpoint robberies. 2 of these convictions are for forcible theft armed with a deadly weapon, and the third is for the use or the threatened use of a dangerous instrument. 2 of these convictions resulted in concurrent 6-year jail sentences, and the third, a YO offense, resulted in a term of 1 to 3 years imprisonment. And in public interviews describing these prior gunpoint robberies, the defendant has admitted that he oftentimes was the person carrying the gun and threatening innocent store owners, and he wasn't some mere bystander in these incidents. Moreover, there's the pending second-degree robbery charge in New York State for a 4th violent felony for which he's been on pretrial release and for which his co-defendant in that case pled guilty and was sentenced to 5 years imprisonment. That's the case in the diner where the defendant triggered a violent attack on a female victim, seemingly because the defendant suspected her of filming him on her cell phone, resulting in Senior lunging at the victim to snatch the phone and Senior's underling doing the dirty work of violently choking her out in the melee. Now, for his part, the defense concedes the violence of the prior gunpoint robbery convictions, but argues that these were long ago and the defendant is a new man today than he was back then. And that may be so, Your Honor, but in response, we respectfully note that the recent conduct is every bit as bad, including the defendant leading and supplying a narcotics distribution operation, possessing firearms, and leading a gang wherein he instigated multiple violent incidents that we discussed, including the strip club shooting. In that shooting in October of 2020, victims were airlifted to a hospital, and just because the defendant is now close to the very top of the enterprise and had more junior members pull the trigger and choke out the victim, this does not absolve him of responsibility. Far from it. In short, the only thing the passage of time from his 3 prior first-degree convictions has established is that the defendant has moved up from the more junior role as muscle to a leadership role where he has his underling do the dirty work on his and the gang's behalf. The 4th statutory factor is the nature and seriousness of the danger, and I won't further beat the dead horse. I think that's been covered above in describing the conduct. With regards to flight risk, Your Honor, the government doesn't press this ground as hard as the palpable danger argument, but we do agree with pretrial services. The defendant is a risk of flight. The charges carry a significant mandatory minimum and a statutory maximum sentence of life. The defendant isn't safety valve eligible, and those penalties, coupled with the strong evidence, create every incentive for him to flee and not serve the lengthy sentence that he faces. And ultimately, notwithstanding the self-surrender in this case, the defendant's conduct in the moments after he learned that the FBI was looking for him, whereby he dropped his phone, made his way from Atlanta to New York and several states in between, and somehow evaded detection and apprehension by the FBI, who was looking for him during a nearly 2-day period, shows both an ability to skillfully evade law enforcement detection and the willingness to do so, at least for a period of time. In short, Your Honor, the defendant has not rebutted the presumption in favor of detention, and in the end, as pretrial services has recommended, the defendant poses a serious danger to the community and risk of flight. Detention is warranted.
I have a couple of questions. One is, can you just, when was this diner incident that is the basis for the open New York County charge?
In 2018, Your Honor.
All right. And second, the indictment is kind of opaque about the specific circumstances of the firearm in aid of racketeering charge against this defendant. Can you elaborate on what the government's evidence is in that regard?
Yes, Your Honor. On the defendant's iCloud, there are photos of several guns. There's co-defendant testimony recorded during a surreptitious prison visit that the defendant always had a gun on him. And we know the defendant possessed significant quantities of narcotics, including marijuana, from the Instagram photos and from his correspondence with other members of the gang. So we know that the defendant possessed firearms frequently while possessing narcotics, and this was in furtherance of his narcotics trafficking operation.
Thank you, Mr. Felton. I'll hear you, Mr. Kastouris.
Thank you very much, Your Honor. Good morning, sir. But please, the court, we fully recognize, as we have in our submissions, the seriousness of these offenses. We have recognized that Mr. Senior had a prior robbery for which he served 6 years, a robbery that occurred some 14 years ago. And however, we have therefore in turn offered a very serious and significant bond in this case. We did not approach the court for over a month with a bond with just some co-signers. We knew that a significant bond would be appropriate in this case, and so we have compiled a $2.5 million bond secured by 5 properties with equity in excess of $1 million and co-signed by 13 responsible suretors, most of whom are, or all of whom are on the phone with us today. This bond would be accompanied by the strictest of pretrial conditions, including electronic monitoring, home confinement, surrender of all travel documents, drug testing, and strict pretrial supervision. And so when the government asserts that we have done little to assure the safety of the community, at least with respect to cabining...
Has joined the conference.
To confining Mr. Senior in his home in New Jersey with his wife and his daughter under conditions as strict as this, along with the property and sureties, which essentially come close to fully collateralizing this bond, I submit to the court respectfully that we have submitted much to assure the court as to the safety of the community. Your Honor, your question is the question that, quite frankly, I've had in this case for some time, and that is, for example, for the 924C conspiracy. There is no evidence, in my view, put forward by the government sufficient to assuage this court or convince this court as to the strength of that part of the case. The government has put forward photographs of weapons. Mr. Senior is not in those photographs. He's not possessing those photographs. And as we stated in our reply, just as an example, we say the government is presenting the court with photographs of weapons that are promotional photographs. We may not like them. Many may not like them, but that's what they are. And when the government responded to our motion, what did they do? They did exactly that, Your Honor. They posted or submitted a photograph of a weapon that had a caption of "Gripped Up." Well, "Gripped Up" is a rap song that was, in fact, recorded a few days before that. That's what that photograph is. That Mr. Luster would go and talk to Mr. Reed or anybody else and say things about Mr. Senior for whatever reason he may want to, that's not evidence that Mr. Senior was ever in possession of a weapon or ever in possession of a weapon in conjunction with the charges filed. Let's talk about what's real. What's real is a witness statement that I received from the government a few days ago. It's redacted. I have no interest in
has joined the conference.
I have no interest in disclosing names or anything like that, but this is a witness who is proffering, and he is a cooperating witness with the government. And what does he say? He says that he knows Mr. Senior since 2015. Now, I'm assuming this was partially a Brady submission. He knows Mr. Senior since 2015. He advises that he never sold drugs with Kaz, nor did he ever know or hear about Kaz being involved in the sale of illegal narcotics. He does talk about credit card scams, but that's not what we're talking about now related to danger. And he also advised that he never observed Mr. Senior carrying a firearm. Now that's real evidence.
I just want to interrupt you. This witness that you're relying on implicates Mr. Senior in credit card fraud?
He talks about credit card scams. But when it comes to weapons, now this is a fellow that knows him since 2015. And he's never seen Mr. Senior in possession of a weapon, notwithstanding the blathering of another defendant to yet another defendant that he always has a weapon. Mr. Senior's appearances are very public. They're videotaped. He's never seen with a weapon. I haven't seen a photograph with a weapon in his possession. I have a letter from the production company that produces many of the photographs and many of the videos that Mr. Senior is involved in. And they specifically state that all of the weapons are props. The name of the company is Street.
Raphael Cameron.
So left the conference.
So here's a witness that the government, I would suppose, believes, because this is a cooperating witness who, for the last 5 years, has not seen Mr. Senior with a weapon, has not seen him committing any robberies, has not seen or known him to be involved in narcotics. So you've got photos of weapons, and you've got this fella visiting Mr. Reed, telling Mr. Reed that Mr. Senior mistakenly fired a gun at a poker game. Well, let's just think about that. This was a wired room. The government installed a listening device. The government makes clear that, in fact, Mr. Senior also visited Mr. Reed. Where are conversations where Mr. Senior is talking about such things? I mean, I certainly don't think it's something to brag about, but you would think, given the context and the landscape the government has painted here, that the first thing Mr. Senior would be telling Mr. Reed is, you're not going to believe this, I was playing poker and fired a gun. So what the government proposes in terms of the weapons charges are photographs that don't have Mr. Senior in them, photographs for which they can never prove they were real weapons, photographs that are clearly, it's really undisputed, are promotional photographs for a rap song that was recorded a few days before, and then statements by somebody else to yet somebody else about things about Mr. Senior. This is a multi-year investigation, Your Honor. I was informed that we're getting 4 terabytes of discovery as the initial provision. Where are there any photographs of such things? The government wants to attribute the violent acts of others to Mr. Senior. A jury will decide that at some point thereafter. But there still are no claims that I can see as we sit here today since 2013, when Mr. Senior was released from prison, where, one would suppose, if you take the government at their word, he gets out of prison in 2013 and begins his, I suppose, ascension to the top. Well, where is the activity in 13, 14, 15, and 16? Where is there any violent activity attributed to Mr. Senior? There is none. And I respectfully submit that there is none because there was none. The government points to, these interviews. I've seen them all, and they're easy for Your Honor to see. And they are interviews about the past. They're interviews about his childhood. They are interviews about what happened in his life up to the age of 20 when he got arrested for that last robbery. In our submission, we have provided to the court a February 2019 interview that was conducted by, I think it's called Montreality. Now, Judge, I don't know. My understanding was that all you needed to do was click on the image and it would come up. It's on YouTube. Your Honor, how does the government square those words? This interview is not posturing. And very interestingly, he doesn't hide his otherwise public image. He's sitting there with a diamond necklace and his 2X brand, and it's all shiny, and he's dressed nicely, as he sits and tells people that you don't get paid for being a gangster. You can't get paid. The only payment you get is death or jail, guaranteed. There's no gangsters getting rich and chubby, move to Miami. You don't go to heaven. It's a lie. It don't matter what the preacher says when you're getting buried. Oh, he was a good man. They shot him for no reason. You're going to hell. You're doomed. You're doomed 2 times. You're finished. If you ask me, that's the government's summation in this case. And Caswell Sr. is providing it in February of 2018 to anybody that'll listen. And if you go through the balance of the interview, he talks about his childhood. He talks about how on the streets they don't tell you that you're going to lose your family and they're going to lose you. They try to glamorize it. So I suppose at the end of the day, Your Honor, and there's been much litigation about the admissibility of rap songs, the admissibility of lyrics, the admissibility of photographs, and they do need to be tied to the activity. But in terms of a jury deciding at some point in the very, very distant future, which is the real Caswell Sr. relative to these charges, I submit to you most respectfully that what we have provided to you are 2 sides to the story. So the law provides that it's only a limited number of individuals that should be detained pre-trial. And we also do cite for the court, and you know, I have to say the government's response to this, it was unfortunate, because the pandemic has created a situation that should be considered by the court in conjunction with the other 3142 factors. We're not suggesting that we open the doors to the prison so people can prepare their defense. There's no question that everybody who's incarcerated right now is living through more of a hell than we on the outside are living through, as at least we're able to put our masks on and move about somewhat freely. I cannot visit Mr. Senior. I haven't been to the MDC since October. I haven't been to the MCC since March. The notion that a defendant can prepare a defense and effectively review discovery with counsel, with 1-hour video meetings with not very good audio, or 1-hour meetings at the jail when they're ever to be resumed, which they are not right now, is foolhardy. It's not true. And my only point is that this is a factor that should be considered in conjunction with the other factors. And when a defendant such as Mr. Senior puts forward valid and viable arguments as to the strength of the evidence, and then puts forward a bond in the amount of $2.5 million, almost fully secured with very strict pretrial conditions, I submit to this court respectfully that the court should consider also his ability to prepare a defense, his ability to advocate for a speedy trial if he does find himself in a different situation than his co-defendants because he was able to prepare. The bottom line is we should all strive to give every defendant in this country the ability to prepare a defense effectively. And my question in my response to the government is rhetorical, but I would ask the government to just think about it. If we did turn the tables, would the government agree that it could prepare its prosecution in this case if it had access to its agents, access to its witnesses for an hour at a time to review, 5, 6, 7 terabytes of discovery for the first time? Of course not. They could never be ready, and they'd be singing a different tune if it were the government in that position. So all I'm saying is that is something that should be considered. With respect to flight risk, of course the government is not pushing that too hard. And here again, the government shouldn't be pushing at all, in my respectful opinion. I understand the exposure. I understand the seriousness of the offense. That's why you have the type of bond you have before you. But honestly, Judge, it is the gravity of the offense. It is the exposure in this case, when considered with the fact that Mr. Senior voluntarily surrendered, that puts him way over the top in terms of not being a flight risk. Because if anybody was even remotely a flight risk, this is when you run. And, you know, the government's assertion as to his conduct upon finding out that he was being sought, well, let me say this. The word was out that Mr. Senior was being sought. The press reports spoke of violence by many members of this gang. You cannot blame a guy, and respectfully, Judge, I'm speaking rhetorically, one cannot blame an individual for figuring out a way to surrender without being shot. And I'm not saying that they were gunning for him, but obviously it's a very tense situation when the government is seeking somebody who is involved in alleged violence. What did he do? He called me immediately, interviewed me, he hired me. These were no rounds. These were no rounds of negotiations. I spoke to the agent who was at his house trying to speak to his wife. He was courteous enough to conference me in with the government. This was the night before he surrendered. I asked for a few days so he could get his affairs in order. They said no. We said okay. So he's in Atlanta, very far away from New York, much closer to anywhere he wanted to run. So what did he do? He fled to the jurisdiction that he was wanted in and then walked into a precinct.
Mr. Casares, I don't mean to cut you off, but I take your point on this, and frankly, I think risk of flight is the least of our problems here.
Well, that was kind of my point, and I'm glad we got there. You know, Judge, I do understand any concerns for danger here, but I think that your point is most valid. I do think that you know, there is really a question as to whether there is sufficient evidence here as to danger, whether there is sufficient evidence, certainly with respect to the 924C. With respect to the narcotics trafficking, I mean, let's be clear. All you have are some photographs of Mr. Senior in front of bags of marijuana, a drug soon to be legal in the United States. And I'm not saying it's legal now. But my point is that government has not said a word to you about the actual basis for the B1A. There is no evidence of trafficking in anything else but marijuana at all. And their own witness has said that he's never seen Mr. Senior involved in narcotics. There's nothing, I've heard nothing, not a post, not a text, not a photo, no evidence whatsoever of him trafficking in controlled substances. And so I do think respectfully that even those charges are going to be difficult to prove. Your Honor, I mean, you've read our submissions. I know that I've gone on for some time here. You know, the other examples by the government again are this one co-defendant talking to somebody else about him in the same wired room that Mr. Senior would have been overheard saying whatever he's saying. And with respect to the Florida situation, Judge, you know, it's easy to just blame somebody for being at a particular place. But, you know, what happened here was that, you know, Mr. Senior's down there with his family. He's celebrating his birthday. He's taking photographs. He's taking celebratory photographs. He is not armed. He is not in any way conducting himself in a violent manner. Now, I have to think that this whole episode had to be videotaped. This is a strip club. I have to think that they have, you know, tapes of the outside. I'd welcome, you know, seeing them. But he is not telling anybody to do anything. And while the text messages in the complaint do mention him, it's very clear that he is not telling anybody to do anything. Interestingly, somebody, according to the complaint, after words are spoken, reaches for their hip. You know, that would be self-defense. I mean, it would be possession of a weapon, but that would be self-defense. It's very clear Caswell Sr. is not armed, and he's not down there looking for trouble. So, you know, again, and he's not charged. Now, if you look at the government's recitation here, if he's the big boss and he's directing violence, well, then he would have been charged. There is no evidence sufficient to charge him with that. And finally, with respect to the diner incident, I don't see how you could possibly say that this is a gang-related incident. He is in a diner, sitting across from a woman half his size. She's videotaping. She asks her to stop. He does not direct anybody to do anything to her. He self-surrenders in that case. We attach the video that we have for the court's review. He surrenders in that case. He's offered a misdemeanor and refuses because he didn't do anything. It's a fellow with a robbery conviction that did 6 or 7 years, Judge. You get offered a misdemeanor and a CD in state court, and you don't have to keep going back to court, especially when you have a prior record. It doesn't add to your predicate status or anything like that. And he's certainly not thinking about Chapter 4 criminal history points. He refuses a misdemeanor because he didn't do anything. So, again, the government is attributing somebody else's conduct to Mr. Senior. So the simple question is this, Judge. Aside from the innuendo of he's some big boss directing people to do things, the government has not come forward and put a gun in my client's hand. The government has not come forward and giving you any evidence of him directing anybody to commit any kind of violent act. The government has not come forward and say, Judge, we know that he sold cocaine or heroin on a particular date. We searched his house and found money. There is nothing except inferences from what other people have said and photographs that he has posted to support these charges. And again, that doesn't mean I'm asking you to simply release him on a $50,000 bond with a signature. What I am respectfully submitting to you is that Mr. Senior can be released on a $2.5 million bond with immensely strict pretrial supervision that will keep him in his home. Everybody that he's accused of ruling over, so to speak, is incarcerated. And that really should assuage the court's concerns as to safety. I want to also just point this out to you, Judge. There's also this argument by the government that this same fella is overheard stating that Mr. Senior asked him for protection. Well, here again, we don't have Mr. Senior doing that, and I know the government has tens of thousands, if not hundreds of thousands of texts. Where is there a text for Mr. Senior saying, I need protection? But moreover, if he's such a danger to the community, why does he need protection? I want to tell you, Judge, there was a short while ago that Mr. Senior and his entourage were entering the Barclays Arena. They were attacked and shot at, and there's a video of it. So far from being protected by his entourage of armed individuals, they ran like chickens, just turned around and ran out of the place while they're being chased and being shot at. So far from being a man who needs protection, there was no protection. And aside from one guy bragging to another guy because he wants to brag to another guy that he's with Caswell Senior, a famous rap artist, there is no evidence that he ever asked for protection, that he ever wanted protection, or anything of the like. These are words of somebody else. Your Honor, we have given the court some of the finances, Mr. Senior. We have addressed the situation which we would ask Your Honor to consider.
The conference.
Mr. Senior is more than happy to provide a full financial statement. His lack of doing so is on me. He didn't have specifics. I told him we would provide specifics. We've given the court his 2019 adjusted income to the penny, what he has in his bank accounts. We've explained the OnlyFans thing. He made, I think, $29,000, not $1 million, and that can be verified. Your Honor, this is a huge bond. with very strict conditions. All of the sureties are available to be interviewed. We have all of their documentation to support their ownership of the properties, the equity in the properties, the outstanding balances, and the value of the properties. We have W-2s, tax returns, and everything else. And the fact that Mr. Senior is not a millionaire who can post all of this on his own, again, most respectfully to the government, that's not fair. We post bonds all the time. In fact, most of the time, it is family members and friends over whom there is moral suasion by a defendant that they would not ruin the lives of 10, 20, 30, 40 men, women, and children by fleeing. And Mr. Senior has made it very clear in his conduct that irrespective of what he is facing, he faces justice and he surrenders to do so. So I have been long-winded. I really appreciate your patience, and I would respectfully submit that a bond in this case should be granted.
Thank you, Mr. Kasouris. Mr. Felton, anything else?
Yes, Your Honor. I'll try to be brief this time. Just to respond directly to a few things from defense counsel regarding the October strip club incident of this year. The defense counsel mentions that this could have been self-defense. Your Honor, this was not self-defense. He told the rival gang member, "You want to die tonight." Right. Someone grabs for their hip. Chrysler shoots the Crip and somebody else. So this is not self-defense. He says, "You want to die tonight." That prompts the shooting.
Who
With respect to the defendant says, "You want to die tonight."
Okay.
As indicated in the text message from Chrysler. Your Honor, the defense counsel mentions that this has not, the strip club shooting has not been charged yet. That's true. The government learned of this last week. The government is actively investigating all parties to that, including the defendant for their role in that. So that's the current status there, but the investigation certainly has not concluded of that incident. With regard to media interviews the defendant has done, defense counsel references interviews where he said good things about the community, and he references that interviews where he mentions his violent past are about the violent past and have nothing to do with the present. I would just reiterate the Nick Cannon interview from 2019 where he says, "Still Abe." So he's currently still a member of Gorilla Stone. With regards to the witness statement we heard about, that was disclosed to the defendant in an abundance of caution. They asked, how come this defendant, the witness has not seen the defendant with guns in 2016, 17, 18, 19, 20? How come that person didn't think the defendant or know if the defendant was in Gorilla Stone during those years? Simply, Your Honor, that witness has been incarcerated since 2016. And that person is not a member of Gorilla Stone, so it's utterly unremarkable about what he knew in 2015 about this defendant's gang affiliation. Moreover, in that witness statement, that witness, who also says he had evidence of this defendant's gang or credit card scamming, also mentioned that he now knows that he is, in fact, in Gorilla Stone. So he knows that he's in Gorilla Stone now. He's been incarcerated since 2016. So there's nothing remarkable about that witness statement. If anything, it furthers the government's case. With respect to the surreptitious recordings of Dick Wolf, of Dwight Reed, those recordings, the reason why we have not introduced evidence of what this defendant said to Reed is that when the recording bug was up, we were recording Reed with others. I do not believe we have evidence of this defendant's meetings with Reed. So that's why we're not introducing the things that were said during those meetings, although we do know that he did meet with Reed as indicated in our bail submission. With regards to the reliability of what Luster said to Reed, they don't know that they're being surreptitiously recorded. They think they're meeting in private. They discuss all kinds of incriminatory conduct of Gorilla Stone. There is no incentive for them to lie or make things up there. It's a candid conversation where they didn't know the government was listening. It's extremely reliable evidence of this defendant possessing guns. Additionally, with respect to firearms, we've heard that some of the posts might be related to promotional materials connecting with the release of a rap song. This doesn't address the iCloud photo of at least 5 dangerous firearms on the defendant's iCloud. This is not a public photo. This is not something he was sharing to hype a song or anything like that. This is what he has saved on his phone that he doesn't think anybody else is looking at. Your Honor, for all of these reasons, everything in our submission, everything in our opening statement, we submit the defendant is a danger to the community and a risk of flight and should be detained as recommended by pretrial services.
Your Honor, if I very briefly, I just want to make one thing clear. I was not saying that any actions were taken in self-defense in Florida. My point was that when somebody reaches for a gun, if Mr. Senior was armed, then you would expect that he would have taken it out. My point is that he wasn't armed, and that was the only reason I made a reference to self-defense. With respect to Luster and Reed, Judge, even though they may not think anybody's listening, Luster may have every reason to be bragging about being around Mr. Senior and saying things to Mr. Reed. It does not make those statements reliable, especially when the government has absolutely nothing to corroborate, Mr. Senior being in actual possession of weapons other than photographs.
Thank you, Mr. Kasouris. All right. I have considered the extensive written submissions I alluded to earlier, the nature of the charges, the information reported by pretrial services, and counsel's rather extensive arguments and proffers in this hearing. And I have to say, defense counsel has proffered what is, by any standard, a formidable bail package, and particularly coupled with this defendant's relatively high profile in the community, and the fact that he did surrender upon within a short time frame after learning he was being sought by the authorities. I cannot find that there are not conditions available that would assure the defendant's reappearance in court. However, danger to the community is a different story. Frankly, the defendant's role in this organization is a little bit difficult for the court to fully understand, and I think I take some of Mr. Kasouris' arguments. For example, posting photographs, unconnected to time or place. We could all post photographs of unicorns, and that doesn't mean we have them in our homes or whatever. But when you go back to the history and characteristics of this defendant, and this is something that the defendant or counsel can't do anything about at this point, but this is a defendant who has over the last decade and a bit more managed to rack up 3 serious violent felony convictions, the most recent of which resulted in a significant term of imprisonment.
Has left the conference.
And this defendant was apparently on parole until 2018.
Has left the conference.
And relatively shortly after being discharged from parole, catches this new charge, which remains pending against him based on this incident in the diner. And of course, it is of great concern to the court that this defendant apparently continued to participate in the affairs of this Gorilla Stone organization while out on bail.
A participant has joined the conference. On
the Manhattan diner incident case, and indeed the recent strip club incident involving Mr. Chrysler is another thing that's transpiring while the defendant is already out on bail. With regard to the fact that violence seems to be being perpetrated by associates of Mr. Senior, as is the case in the diner incident and also in the recent strip club incident, it is entirely plausible to interpret that as evidence of Mr. Senior's relatively advanced position in the organization. He doesn't have to get his hands dirty. He has people to do that for him. Looking again at the 2018 incident as well as the recent incident at the strip club, it is quite possible for the court to infer that people that cross Mr. Senior get hurt, although perhaps not by his hand personally. There is a statutory presumption of detention here on danger to the community grounds. Again, the court believes that that statutory presumption is reinforced here by this defendant's prior established conviction record, as well as by these more recent incidents proffered by the government. So I find that the proposed bail package, formidable as it is addressed as financial packages often are, primarily to risk of flight considerations, and I find that the defendant has not rebutted the presumption with regard to danger to the community. So I'm going to order Mr. Senior detained on danger to the community grounds pending trial. With regard to the challenges that are posed by the pandemic to trial preparation and so forth, those challenges are real. All of us are challenged in the current environment, but in the face of a dangerousness to the community determination, I can't permit that to override the court's responsibility with regard to the safety of the community. We'll all have to muddle through and hope for that some of these challenges will abate in the coming months. So that's my ruling. Is there anything else from the government, Mr. Felton?
No, Your Honor. Thank you.
Mr. Kasouris?
Your Honor, there's one very brief issue that I just want to put on the record. We are unable to visit with Mr. Senior, and we do get some calls, but what I've done is I have set up a Securus line, but that is a line for which the calls are recorded. We have sent an email.
Left the conference.
We've sent an email to the company trying to explain to them that this is an attorney's number, it is a business call, and it should be privileged. So I just want to put on the record that, it's GTL.
A participant has left the conference.
That the government should consider any calls between myself and Mr. Senior, even though they're recorded, as being privileged until this company so designates. I have very limited contact with him, and I need to be speaking to him.
Mr. Felton?
Yes, Your Honor. The government certainly deems conversations between the defendant and his counsel as privileged.
I certainly think you do. It's just that they tell you when this call starts that it's being recorded and can be disseminated, and that's all.
And Your Honor, there's one further thing for the record. We understand that video conferencing between the defendant and his counsel will resume on Monday at Westchester County Jail. It was temporarily halted due to a COVID quarantine issue, but now that's expected to complete after the 14 days on Monday, and they'll be able to video conference again.
Well, this is an ever-changing story, but as I indicated before, we all have to muddle through and get past these challenges. And I encourage counsel to work together to try to
has left the conference.
Meaningful attorney-client communications between Mr. Koussouris.
Brandon Belmonte.
All right, very well. Thank you all.
Thank you, Judge.
Stand in recess.